Hello, class. It is the week of February 4th, and we are about halfway through the class. So I'm posting this video to inform you that it is time to submit a research topic and to talk a little bit, first of all, about research papers. And I'll shortly, today, probably in the evening, today's February 6th, I will set up a uh, place for you to post your topics. Now, what I mean by a research paper is not really the kind that you would think of in college as extensive research. You don't have to go to outside sources. It's very bare bones. What I mean by a research paper is to use one of the postings that I've made, such as the 3 strikes and you're out law, such as the Casey Anthony case, also such as the Duke lacrosse players case. I'm using these cases so that you can have material to make commentary. You don't have to use them, but it just makes it a lot easier if you've already done the research. So if you've been taking notes, following the posts, the forums, the videos, you'll know that basically we've taken a broad look at the court system, specifically the state system. We've taken a look at the different roles of the players in that system, and we've begun to take a look at the preliminary stages in the criminal process. Now we're going to do some catching up on that last portion and catch up with the readings this week so that we can prepare you for the exam. The exam will be in about a few days. It'll be just a few short questions and short answer questions and an essay question. But it will cover the readings up to this point. I'll post a further video preparing you for that exam. So look for that in the coming day so that you can do that. But when you post your paper topic, just tell me what, if any, of the postings that we've already had interest you and what angle you'd like to take. Some of you are criminal justice majors. Some of you are taking this as a political science class. So I understand there's different angles you can take to a case. You could take a social sciences angle, a political science angle, or you could take a lawyer-like angle to a case. The reason it's called a research paper is because I'd like you to use one of the sources we've been talking about in the course, one of the postings, perhaps some media articles, any videos that you see, to talk about one of those issues that we've highlighted. Oh, one I haven't mentioned is the bail bondsman process in the criminal justice system, which in Washington got kind of interesting because there was a little scandal about how people were getting out for less than the ordered bail because bondsmen were negotiating to the bottom on some cases, and some pretty violent people got out. One in particular committed a murder. So take a look at that from last week, that video that I posted, if you're interested in that. I've tried to give you a pretty good helping of different angles, really interesting cases. If you're interested in one of those, pick those and give me a short, maybe, I don't know, 1 paragraph to 2 paragraph outline of what you'd like to do with your research paper, just so I know that you're on track. And then the paper itself will simply be something with a thesis paragraph. In other words, taking the broad topic and something about it that's original, that you want to highlight, that you think calls for change, or that is a problem in the system, that it is an explanation for why something happened the way it did. It could even be something that we've discussed, and I'm interested in seeing if you've been paying attention to the readings, to the videos, to the forums. I'm interested in seeing if you've thought it through and are interested in one particular angle. You can bring your own research to this as well. Research simply meaning some journal articles, some newspaper articles, a reference to a book, some outside source, if you are not picking the sources that we've highlighted for this class. Give me that essentially this week by the end of this particular particular week of the class, and I'll set up a place on Moodle where you can post it. I apologize for not having that up yet. I've gotten some emails from students already to want to do that. It looks like you're already on the way to selecting your paper topic. And the paper, the description of the paper is in the syllabus. It doesn't have to be very long. Just follow the description of the syllabus, and that will be adequate. It doesn't require anything more than what we have posted in this class. So don't be alarmed or think that it's a heavy-duty paper at all. You don't have to cite any other sources than what we've got there. The exam I'll post by Saturday, and I'll give you a few days to complete that. But all the readings up to this week will be covered in the exam, and I'll post a review video, as I stated, to cover that. Now, just to highlight what we've just got done talking about in this class, is the preliminary proceedings of the criminal justice process. Those tend to look really routine, and if you've taken a look at the flow chart, you'll see what we're talking about really is arrest, charging, and bail. But I wanted to highlight those proceedings because oftentimes what is done in those preliminary proceedings either gives you a really important clue as an attorney in the case or as an observer as to what's really going on in the case. For example, in the Duke Lacrosse case, we've talked about how there weren't certain warrants issued right away that one would expect. There weren't immediate charges brought, and sometimes that's not unusual in cases, but in a violent case, a case involving felony violence, right up there with one of the worst crimes imaginable. You can't think of anything worse than perhaps murder than a gang rape. You would definitely expect to see immediate charges brought, even if those charges are overbroad, simply to get people in the judicial system, to get them booked so that we know where they are, to get their identifying information, to get fingerprints, photos, and to get them secured so that they don't commit another crime, or to get them to speedy bail hearings so that the prosecution can present evidence as to which one of them should be detained further. Sometimes people are detained as material witnesses, and the charges are reduced. The police have a lot of power, the prosecution has a lot of power to bring a charge, even if they don't have an identification of a perpetrator yet. As long as they know the general pool of people that may have done it in a group, they can bring all those people to court and just release them when the bail hearing comes. So I highlighted the Lacrosse case because no charges were brought in the immediate future of that event, and that's a huge red flag that there is a trumped-up case. If it truly is a violent crime, there's going to be much more massive action, many more incarcerations than there were in that case immediately. I mean, nobody in that case was incarcerated right away. I've been involved in a case very similar to that case the same year, and every single one of my clients was incarcerated, or every single one of the defendants was incarcerated, including my client. My client was the only one released on bail, and the bail hearing was extremely important in that case, because my client was a potential witness in the case, and the DA's office knew that they had a shaky case against them, and they wanted to try to get his cooperation, so they weren't even opposing release on bail after they had incarcerated him. But the process of incarcerating him was so important because it was a violent felony, and until those few days pass after the incarceration to determine bail, the prosecution has not looked at it enough to know whether they have a solid case against somebody. But still, the arrest is warranted because the charge, at least, is serious enough. And I would say, even if you don't have everybody ID'd, as long as you have a reasonable pool of people that isn't, a large crowd or something, and in this case, good police work, in the Duke case, you could have gotten a pretty good feel for who was present at the party and eliminated some people that weren't present pretty quickly. That would be good police work. But it doesn't look like they even did that, simply because we know now, but the defense didn't know this at the time, that the victim Mangum was not even identifying who her perpetrators was not even identifying the perpetrators in an effective manner. So that case really highlights how important those preliminary proceedings are in a case. Often as well, a person's release on bail or not is a matter of the effective ability for the individual to present their own defense versus the safety and security of society. If a person is incarcerated, they really are going to have a hard time showing that they can be rehabilitated, or that they can get treatment for an alleged crime, or that they can help in their defense in any effective manner if they're incarcerated. So getting out on bail is extremely important, not just for the sake of freedom. On the other hand, for the prosecution, staying incarcerated for the duration of the case can be important because the individual might commit another crime, is violent, might flee the jurisdiction. A third reason that bail is important is because the judicial system is typically strapped. Jails are really overcrowded, and so judges and even prosecutors, as well as defense attorneys, are looking for ways to speedily process cases so that the jail system is not so overcrowded that when the real violent felons come to court, there isn't some problem with making room for them in the jail. So there's a lot of action that involves granting bail. In fact, standard in a large number of cases involving assaults, domestic violence, drunk driving, traffic cases, even some violent felonies where the violence is somewhat not egregious, not really over the edge. You have routinely the granting of bail. So that's really the norm in these cases. And of course, the judicial system's concern is to make sure that the most violent felons are incarcerated, and the others, even if they have potentially sort of used violence against significant others or family members or the public, that if that's the first time, they get released on bail with certain conditions. And conditions are imposed so that the defendant knows that if they reoffend, they can be put in jail right away and their bail revoked. So a big part of this is, in the normal course of business, a lot of people are released on bail. And for the defense, that allows a very effective case to be brought because a lot of action can be taken during the pendency of a case that wouldn't be allowed if the person was incarcerated. That just goes without saying, really. So arrest, bail, and then charging. The charging is the first time the defendant gets to see the details, that is, the factual summary of what the state is charging him or her with. Before that, there's just really a one-sentence charge with the statute. And then when the actual charges are brought at the arraignment, then the process of going into the supporting evidence begins. That's where the critical stage of investigating the case begins for the defense. The critical stage of proving up the case for the prosecution begins, is that period of the bringing of charges. In the Duke Lacrosse case, we talked about how in our forums there was a large delay in the bringing of charges, huge clue that the prosecution was groping for evidence, and we won't discuss it too much further. But I think that that's I think personally more than the dismissal of the charges eventually in that case, those preliminary proceedings were highly interesting, to say the least. Not to mention the use of the media by both the defense and the prosecutor. Often one side can try to prove their case in the media effectively. There are ethical rules that bar doing that in a way that is meant to smear one party or the other, but often there can be a lot of banter in the media about a case ahead of a trial, especially if that case has gotten a lot of attention on its own without the prosecutor stepping out. The jurisdiction that I happen to practice in, the prosecution was very cautious not to talk a lot about their cases in the media. But sometimes the media was so aggressive that the defense had to get out in front and speak to the media to dampen the hysteria in particular cases. I was involved in some cases that were like that, where I spoke to newspaper reporters, spoke on the evening news, but the attorney in a case such as that has to be very guarded not to try to overly influence the public, because the public is the jury pool, not to try to disparage the other side's case. And my strategy was often to speak about just the facts, because the danger is you don't know what all the facts are until the case develops, and sometimes you never know what the facts are because you as the attorney were not present during the incident, hopefully. But there are several facts that are undisputed, sometimes a few of which are going to help the defense side, and the defense can talk about them because they might be a public record, or something that is physical, or something that somebody else has said. But I never would speak about what my client would want to say, would never speak often about whether they were innocent, because you don't really know that. In fact, most of the cases they're not innocent. But there are things you can say that can appear to make it look as though a person should be assumed innocent, and I would be pretty aggressive about that in cases where the media was aggressive against my client's interests. That was the case in the Duke Lacrosse case, and I think that's another interesting aspect of that in case you're thinking of research papers. The media's involvement in the criminal process is an extremely fruitful area. I'll see if I can post a video on that, or some source, an article, so that you can have maybe that additional area to use as your research. If you have other areas that you're interested in and didn't see it posted, feel free to email me. For now, though, we'll go with what we've got so far, and I'll look forward to seeing some of your research paper proposals, and I'll start preparing the exam and a primer video to review up until today what the course has been about. Thanks a lot.